No, that I think the Finance Minister has very clearly clarified that the matter is already in the Supreme Court and the Supreme Court will settle the issue. In fact, yesterday also when the private company, the FIIs, on their behalf, a mention was made in the court, in the Supreme Court. The Attorney General who appeared for the government said that government has no objection. Government is also keen on an early hearing so that the higher court, the apex court of the country, settles the issue. It came up in the Supreme Court yesterday and the Attorney General was present. He explained the position of the government, yes.
What happens to the apprehension that if tax assessing officers open up the books of FIIs for the past 6 years, they are well within their right to do that. Don't you think that will open up another can of worms now?
You see, the assessing officers will have to follow the letter of the law. Yeah. Whether he will open 6 years or he will open 5 years, I would not like to comment on that because that's a matter of detail. The law of the land has to be followed. But this, this speculation about the amounts, very highly exaggerated amounts which are being mentioned, I think that is, I can say it is highly exaggerated because in reply to an unstarred question, government has already replied that in respect of the cases where the assessments have been completed, the liability is only about 603 crores, 603 or 602 crores. So therefore, and let us remember, that India has, the countries from which FII inflows are there, almost with 80 or 90% of the countries, India has tax treaties. So therefore, the amounts which will eventually form part of the tax liability will be far too less. 40,000 crore which is being mentioned in various quarters is a highly exaggerated number. I think it's unnecessarily creating a scare which is not correct. You see, when a sponsor sets up a trust, he transfers his shares into the trust. In return, he gets units. So when he gets the units from the trust, according to the current accounting standards, he has to show the market value of those units. When you show that market value of the units, there will be a book profit. But at that point, no cash should have accrued to the hands of the sponsor because he would not have sold the units. The units he would be still holding. So without any cash accrual, there will be a book profit. So therefore, it will affect his cash flow. So at that stage, there will be no MAT. Subsequently, when the units are sold in the market, at that stage, MAT will become applicable.
So how soon do you see a resolution to this entire tussle that we are facing with FIIs?
Well, Supreme Court has agreed for early hearing, and I think after the summer vacation, the Supreme Court should fix a date, July, August or so. The court will fix a date and they will decide.
Find us on Facebook at facebook.com/ETNow and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.